morning. So we are discussing about the Hindu Marriage Act. So in that Hindu Marriage Act, today we are discussing about marital remedies or relics. So coming to the marital relics, already we have discussed that when a marriage is performed between two Hindus, it creates some rights and obligations. So once the marriage is completed and it is a valid marriage, then the parties will get marital remedies or rights under Section 9 of Hindu Marriage Act, Section 9, Section 10, Section 11, Section 12 and Section 13. So coming to the students, what is Section 9? Section 9 speaks about the restitution of conjugal rights and Section 10 speaks about a void marriage. So if a marriage is void marriage, then the parties will not get any rights. So here who are the parties? Students, whenever in Hindu law we call the parties are wife and husband. So if it is a void marriage under Section 11, then the parties will not get any rights. So Section 10 speaks about judicial separation. So when the parties don't want to be separated permanently, then they can take the protection of Section 10, which speaks about judicial separation. Section 12 is voidable marriages and Section 13 is discusses about the divorce. So these sections are called as the marital remedies or marital relics. As already we have discussed that students, when a marriage is performed, the Hindu marriage creates certain rights and obligations among the parties. So here we are discussing about Section 9, which is restitution of conjugal rights. Then what is this restitution of conjugal rights? In Hindu marriage, once the marriage is performed, then it creates an obligation between the parties to stay together. To stay together in their matrimonial home. So they should stay, that is the obligation created between the parties in the marriage to stay together. Okay? So when one of the party, either the husband or wife, has left the other party. So here in the restitution of conjugal rights, as the marriage creates an obligation to stay together, but either the husband or wife has left the other party, here the keyword is without a reasonable excuse. If one of the party has left the other party without a reasonable cause, that is left the other party means they have withdrawn from the society of the other. Then, so if one of the party is left the other party, for example, A is the husband and B is the wife. So here husband has left the wife. So here husband has left the wife without a reasonable cause. So if any reason is there, definitely the parties will get the right to separate. Here in this restitution of conjugal rights, the husband has left the wife without a reasonable cause. So without reasonable cause, if the husband has left the wife, then the wife is the aggrieved party. So what? The aggrieved party may file a petition to the court, that is family court. So under Section 9, the aggrieved party can file a petition in the court. So once the court has satisfied whatever the statements made by the aggrieved party is true, then the court may decree restitution of conjugal rights against the other party who has left the matrimonial house. So here, if one of the party left the other party without a reasonable cause, then the court directs the other party to go and join your party. That is restitution of conjugal rights. So here I already said the key word is without a reasonable cause they have left the party. If any reason is there, then the court will not direct the party go and join. So here, if the husband has left the wife, then the obligation is on part of the husband to prove that there is, if any reason is there is the reason to left the party. If no reason is there, then the court directs to go and join your party. That is restitution of conjugal rights. So in this restitution of conjugal rights section 9, the court directs the party go and join your spouse. So here a question of constitutional validity was raised in different cases filed before the court. This section 9 is violating the rights of the individuals. Because section 9 is directing, if one of the party is not interested to stay together in the matrimonial code, then section 9 is directing to go and join your spouse. Then the constitutional validity was questioned because constitution under article 14, it gives right to equality. Every person is having a right to live as they like. And article 19 gives freedoms. So every citizen, this is right, and the constitution is given to the Indian citizens. So here the person, individual is having the right to stay or to reside anywhere. Freedom of residence has given, and again article 19 has given freedom of any profession, occupation to take. And article 21 gives right to life and personal liberty. Here section 9 is directing to stay together with your spouse, but when the court is directing to join to your spouse, then the question was raised that this section is violating the constitutional rights. So first time this was raised before the case of Sarita versus Venkat Subbaiah in the year 1983. Students, already all know that Sarita is a famous South Indian film star. So she started her career after the marriage. So they used to stay in Rajahmundry after her marriage, as she has taken the profession of acting. Then as at that time we know that in 1983 the film industry is in Madras. So because of that reason she has moved to Madras to continue her profession. Then Venkat Subbaiah filed section 9 petition, restitution of conjugal rights in the district court, and he has filed a petition asking the court to send his wife Sarita back to the matrimonial home. Then the district court has saw the statement, and the district court has thought that yes, it is correct. As she has left her husband, as section 9 says that whenever either party left the matrimonial home or the society of the other, then section 9 makes the party to join together. As once the court has read the statement made by the Venkat Subbaiah, and the court has thought it is true, and it has directed Sarita to go and join Venkat Subbaiah. So here decree of restitution of conjugal rights were given in favor of Venkata Subbaiah. After this decree was given in favor of Venkat Subbaiah, then Sarita has moved to AP High Court. So in the year 1983 she has moved to AP High Court, and her advocate has pleaded that if the court has directed Sarita to go and join the husband, her 14 was violated. Her article 19, she is having the freedom to choose any profession. So she has taken the profession of acting. So if the court has directed her to join her husband, then what about her career? As the film industry is in Madras, she can't go and join. Article 21 speaks of personal liberty of every person. Here her personal liberty was well. And one more thing, the advocate was added that if she has sent forcefully to the husband's house, then husband can use her body. Because of that she may have children. She may not interested to have children. Then how it is affected on her psychological feeling. So after these arguments, the court has thought that yes, section 9 is a brutal section. It should be removed from the Hindu Marriage Act because section 9 is making the parties to stay together even though they are not interested to stay together. So section 9 is constitutionally it is violating the rights of the individuals or the parties and it is making to stay together. And the decision was given in favor of Sarkar. So again in 1984, in Delhi High Court, one more case was filed of restitution of conjugal rights. The parties are Harvinder Kaur and Harminder Singh. In Delhi High Court, this case was filed. So here again, as one of the party was left to the other party, and the party is requesting the court to send the spouse again to their society. Then here the Delhi High Court, what it has thought and expressed that section 9 is a good section. Section 9 of Hindu Marriage Act is helping the parties to stay together. Whenever any clash is there between the parties and one of the party left the other party without any reasonable cause, after some time, if they made to sit together, then re-counseling can be there and they can be having a chance again to reunion them because the marriage is to be protected. The sanctity of the marriage should be protected. So section 9 is helping the parties to stay together. If because of some reason they have separated, it is again giving a chance to the parties to stay together. So Delhi High Court has said that section 9 is a good section and it is helping the parties to rejoin again. So here the section 9, two different high courts have expressed different opinion regarding section 9. So AP High Court has said that section 9 is brutal section, whereas Delhi High Court has said section 9 is a good section. Again, one more case was filed in the Supreme Court in 1984. There also the question raised regarding the constitutional validity of section 9. That is in the case of Saroj Rani versus Sudarshan Kumar. Then what the High Court has said? The High Court has said the constitutional law is different and family law is different. So again these fundamental rights are available against the state. When the state violates our fundamental rights, then we can ask the state to file a case against the state to get back our fundamental rights. So here restitution of conjugal rights section 9 is giving the provision to protect the marriage, to protect the sanctity of the marriage, and it is giving a chance to union the parties. So in the family law, the constitution cannot be taken. So what opinion the Supreme Court has expressed is that if the parties in the family law, they take the constitutional law, then the families cannot be sustained because it is like a bull in the crockery shop. That means if a bull was there in the crockery shop, then what will happen? Definitely it will break the crockery. Say, in the marriage, if the constitution is taken, the marriage will not be